Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There is just about 3 months left to go in this case that has been proceeding for well over 2 years until July 30th, 2025, which is the date that Judge Stephen J. Hippler stated would be the start of voir dire, which is the process of jury selection. That date was set in the court's order that was filed back on October 9th, 2024. I've called it the pretrial and trial order because it sets the trial date, and numerous other pretrial matters. This past week saw 3 significant developments in the case. The first was the defense's motion to continue the trial. That was filed on May 20th, 2025. What this motion is seeking is to have the trial date adjourned, continued to a later date for various reasons that were cited within that motion. Constitutional reasons. The defense is asserting that more time is needed to prepare both parts of this trial, both for the case in chief and also any penalty phase. The issue of a recent mass media television program focusing on this case and presenting evidence that the court believed might constitute a violation of the non-dissemination order and a forthcoming book on this case were other grounds stated as good cause by the defense to continue the trial. As of the 23rd of May 2025, the state of Idaho had not filed a response to that motion to continue. We are speculating, in our opinion, we believe that the state will file a response and that it will likely be in opposition to any continuation of the trial. We anticipate that once the briefings, the motion, response, reply are all filed, that Judge Hippler will entertain the matter at oral argument and then will thereafter render a ruling whether to grant that motion and adjourn the trial or to deny it and to allow matters to continue proceeding toward July 30th voir dire and the August 11th scheduled commencement of the case in chief. The second key event of this past week was the deadline for items that both sides were court-ordered when they received the May 15th, 2025 document and records hold order. This dealt with the aforementioned concern that Judge Hippler had of a violation potentially of the court's non-dissemination order. The court is intent on getting to the root of the matter and find out who was responsible for the same. And in furtherance of that objective, the court directed both sides within 7 days of the date of that order to submit to the court for in-camera review certain information, including a list of all individuals within their respective teams, past or present, who had access to the information, the evidence at issue. Both sides were directed that they were to present this information within 7 days under threat of potential contempt of court charges if they failed to comply with the court orders and any such other civil and criminal consequences as might be appropriate. We noted that between May 15th and the 22nd of May, which appeared to be the deadline, 7 days, that there was no filing of a motion for extension of time by either side, seeking more time to comply with the court's order. The third item was the defense's filing of a motion to permit mitigation witnesses to watch the trial. This item has not yet hit the public docket, although it was filed per the case summary page May 22nd, 2025 as a public record. We know that by the designation of the PDF icon next to the term motion rather than the lock and key icon, which we have seen repeatedly in this case for the many, many items that were filed under seal. This document, we speculate, we believe, may be related to having mitigation witnesses watch the trial, watch the case in chief in the event of a conviction, so that they will have some information that may be helpful to Mr. Kohberger during the next phase. In the event of a conviction, then the matter would then move into the penalty phase. We see that page 1 of the court's October 9th, 2024 order. The matters are bifurcated, meaning this period of time commencing August 11th and running through November 7th, 2025 is inclusive of the case in chief, the guilt phase, phase 1, and, if necessary, phase 2, the penalty or the sentencing phase. We await this filing. Hopefully it will be filed onto the docket early part of next week so we can learn what it is that the defense was asking for with respect to having these witnesses be in the courtroom during the upcoming trial. If you like our content, I would greatly appreciate it if you would hit the like button and consider subscribing to the channel if you are not yet subscribed, so that you will receive notifications when we add additional content. This now concludes this episode of the Indie Zone. Thank you so much for joining us today.